I'm going to call the House Judiciary Committee to order. Madam Clerk, will you please call for attendance?
Chair Lightner.
Here.
Representatives McFall.
Here.
Wozniak. Harris.
Here.
DeBoyer. Johnson. Here. DeBoyer.
Yeah.
He's here. Okay. Shooty.
Here.
Carter. Pope. Green. Scott.
Present.
Madam Chair, you have 7 members present. You do have a quorum.
Thank you, Madam Clerk. And just to take care of the business, I'm going to have Representative Johnson move to excuse absent members. Hearing no objection, absent members are excused. With that, the next item of business is adopting the minutes from May 21st. Rep. Shooty will make the motion to adopt the minutes from the 21st. Hearing no objection, the minutes are adopted. Okay, next up, we're going to have House Bill 4396, sponsored by myself. We have the Super Dean, Dr. Kubiak, on Zoom today to testify in support of House Bill 4396. And basically, the nitty-gritty is we hire certain people to do research in our juvenile justice arena, in all of our criminal justice arenas, actually. And right now we have a barrier where they aren't able to obtain certain data in our system. And so what this bill does is it opens that up, has a contract, basically, and memo of understanding to allow for certain data to be shared with our researchers so they can, put it in a form that some of us simpler people can understand. So with that, Dr. Kubiak, I am going to go ahead and give you the floor, and it's all yours. Thank you.
Good morning, Representative Lightner, and I am happy to be here in this committee that you chair, and thank you to the other members of the committee for hearing this testimony. I am Dean of the School of Social Work at Wayne State University and also the Director of the Center for Behavioral Health and Justice. In that role, the Center for Behavioral Health and Justice acts as the evaluative arm for the Diversion Council for the state of Michigan and is currently working with other funders across the criminal legal system to look at intersections between behavioral health and the criminal legal system in terms of where people end up and what interventions are successful and what may prevent recidivism. In that role, I've worked in various capacities and also on the Criminal Justice Policy Commission with Chair Lightner. And one of the things that we found is that there is a dearth of data that assesses the efficacy of different interventions, whether they're policy interventions like legislative changes or programs that are in place. And recently, there were some state legislative changes to reform and update the youth justice, juvenile justice system. In those legislative reforms, there were a lot of movement towards increased diversion and deflection of youth from the criminal legal system where possible. And we know in the youth system that diversion or deflection usually means that they're entering community programs, whether it's for mental health or substance abuse or schooling. But what happens in this case is that the data on what youth have been diverted from the system is inaccessible, not only to external researchers, but others in the state government, whether it's the executive branch or the legislative bodies. So this bill would allow access to look at what youth have been diverted from the system and allow us to link data. And by us, I'm not saying the Center for Behavioral Health and Justice, I am saying about researchers, whether they're internal to the legislative bodies or the executive branch or external members. But the accessibility of that data to find out who was diverted from the system and look at what those outcomes were and be able to link the data to whether it's a program in the community, whether it's MDHHS, the child welfare system, but really being able to look over time. Were these legislative interventions successful in keeping youth out or keeping communities safe, decreasing mental health? Right now, we can't do that because the data is legally inaccessible. It's not that it's being obstructed, it's that legally it cannot be accessed by anyone. So this bill really opens up that avenues for evaluating and assessing these policy changes and producing data and outcomes that you as legislators can use to inform policy decisions. So I would like to turn it over to you if you have any questions, but I want to clarify one point. Personal identifiers on this data, it's easy to say we're not going to allow any personal identifiers. But because there is no integration of data between systems and often within systems, if you do not have the personal identifiers to link someone to another data system. So for instance, youth who are diverted, if you don't have their name, their birth date, their gender, their race, even their social security, 4 digits at the end of that number, it's hard to say, is this the same person that I'm seeing in the child welfare data, or am I seeing in a program data? But once that data is linked between systems, then you remove the identifiers and no one can know who that individual is. And we look at outcomes in aggregate. So we look at a group, maybe it's a county aggregate, maybe it's a state aggregate. But at that point, once those identifiers are stripped out of the data, then you can analyze it and ask questions like, who recidivated? What programs worked better than others? How long was someone in detention who got this intervention? How do numbers differ across counties? So that's the goal of this legislation. And I hope to work in collaboration with this committee to look at what those outcomes are in the future. So with that, I will pause and I'm happy to take any questions.
Thank you, Dr. Kubiak. None of our members have questions at this time, but I just want to reiterate, what Dr. Kubiak said to the committee and the importance and significance of this bill. This is an issue, like the dean said, that we have dealt with for years and years and years. When I served on the Criminal Justice Policy Commission back before I was a state rep as a county commissioner, we found that we had a significant lack of access to data. And in order for us to make good policy here in the House, we kind of need to know what's going on in our system, right? And so, that's the significance of this relatively simple bill. So I hope to take this up next week, I think, for a vote. So just anticipate that. But with that, Dr. Kubiak, thank you for your time. Thank you for your support today. And I'm sure we'll be talking again soon.
Right. Thank you all.
Okay, and then I'm going to read in cards that I have in regards to House Bill 4396. Nathan Triplett from the State Bar supports the bill, does not wish to speak. I have Michigan League for Public Policy, supports the bill, does not wish to speak. Jen Peacock from the Michigan Center for Youth Justice supports the bill and does not wish to speak. Okay. Okay, we are going to move on in the agenda right now. We have already discussed House Bill 4434, 4262, and 4263, but I want to get those votes out of the way. So with that, we are going to have Rep. Bagol move 4434 in regards to the one-person grand juries. Madam Clerk, will you please call the roll?
To report House Bill 4434 with recommendation, Chair Lightner,
Yes.
Representatives Begol,
Yes.
Wozniak, Harris,
Yes.
DeBoyer,
Yes.
Johnson,
Yes.
Shooty,
Yes.
Carter,
No.
Hope, Breen,
Pass.
Scott.
No.
Madam Chair, you have 6 yeas, 2 nays, 1 pass. The motion prevails.
Thank you, Madam Clerk. With that, we have House Bill 4262. We will have Rep. Harris move with recommendation. House Bill 4262. Madam Clerk, will you please call the roll?
Chair Lightner,
Yes.
Representatives Begol,
Yes.
Wozniak, Harris,
Yes.
DeBoyer,
Yes.
Johnson,
Yes.
Shooty,
Yes.
Carter,
Yes.
Hope, Breen,
Aye.
Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 0 pass. Motion prevails.
Thank you, Madam Clerk. Next, we have House Bill 4263. We're going to have Rep. DeBoyer move with recommendation, House Bill 4263. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Begol,
Yes.
Wozniak, Harris,
Yes.
DeBoyer,
Yes.
Johnson,
Yes.
Shooty,
Yes.
Carter,
Yes.
Hope, Breen,
Aye.
Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Next up, we are going to hear testimony in regards to some probate matters. Rep. Thompson and I don't see Rep. Witwer, but it's her bill as well. So 4418 and 4419. Okay. Oh, just wait. Okay, so first up, actually, I want you to present your bill, Rep. Thompson. So if you want to come up and present on 4418, and I'm guessing 4419, give us the overview, and then we'll read in the other guest speakers and have them come up and help you. Because as far as I know, I have Elizabeth Cutter from Michigan Health and Hospitals who wishes to speak and supports the bill. And then we'll have Nicole Shannon from Michigan Elder Justice Initiative who wishes to speak and supports the bill. He needs a few minutes. Genevieve Marin from Right to Life will want to speak as well, supports the bill. You will not have 25 minutes, I can tell you right now. Oh, I'm like, there's no way. But okay, gotcha. I can see that now. I guess it looks like a 2. But anyways, I'll call you up too. I'll call you guys up in order. All right. With that, Rep. Thompson, you have the floor. Thank you.
Thank you, Chair Lightner, and thank you, members of this committee, for taking up this very, very important and very, very personal legislation. And I also want to give a personal thank you to Representative Breen, who did tremendous work on this last term, and I appreciate the work and the continued work and the bipartisanship that we have put together with this bill. So before I go into the meat and potatoes of the bill, when I served on Family, Children, and Seniors last term, I heard this legislation that was presented by Representative Breen. And it touched me personally because I had actually just went through this with my father. So many of you do not know that Michigan is not a next of kin state. You have heard terms such as surrogate decision maker, durable power of attorney, next of kin. These are all things that we hear in terminology throughout healthcare, probate, and in the general public. But in reality, Michigan is not recognized as a next of kin state, and that's just that simple. So I learned this when my father became ill in Kentucky. He was born and raised in Kentucky. He moved to Michigan, spent 45 years, 50 years here in Michigan, and after divorcing my mother, moved back to Kentucky. I got a phone call that he had had a heart attack and that he was not expected to survive. So this was 2 summers ago. I went to Kentucky and spoke with the physicians and found out that he had an inoperable hole in his heart and his aorta was extremely calcified. And as a nurse, I can tell you that means that it's not operable. So he was given 10 days to live. My knowledge of how the system works from being here in Michigan, I asked the doctor, while I'm here, I'm his next of kin. Should I get power of attorney? Do I need to bring in a lawyer and get paperwork signed? Because I know with his condition, he may be alert right now, but within a few short days, he's going to fill up with fluid and he's going to become septic and he's not going to be alert anymore. The physician clearly told me no. Kentucky recognizes you as next of kin. When he becomes confused, you make those decisions for him. Him and your mother are divorced. You are his oldest child. You are his next of kin. Okay, great. I made arrangements to bring my father back here to Michigan because that's what he wanted. He wanted to pass away with me, my grandchildren, and his other daughter. He signed all his paperwork in Kentucky when he was alert and oriented that these were his final wishes. He wanted to go hospice. He didn't want any interventions. This was all documented and sent over to Michigan with him in his packet. During the 3 or 4 day process of getting him to Michigan, when he got to Michigan, I put him in a skilled nursing facility close to my home, and he signed on to hospice. When I spoke with the doctor there that first day, everything changed for me. I was told that not only did his DNR not cross state lines, which I didn't know that that was a thing either, and I would hope that we could take up that legislation at a later date. But I was also told because now he is not alert and oriented, he is confused, I have to go get guardianship of him in order to make his final wishes become law. Meaning they would have to do everything and anything possible to resuscitate him. With those of you that I know serve on this committee, Representative Harris, as performing CPR and medical interventions, we know that when a patient chooses their last will and testament on what they want, that should be respected. And I was told that it couldn't be respected any longer because I had to go to court and get guardianship of him. We live in Wayne County. He had about 3 days to live. I did not want to spend the last 3 days of my father's life in court trying to get guardianship of him when I am his daughter and I should be able to make those decisions for him. And I will tell you, I'm a strong advocate of hospice care, and I believe solely that I spent those 3 days ignoring what everyone said. I firmly sat at my father's bed and I dared them to touch him because he did not want resuscitation and he was frail and he needed to. Death and birth are very similar. I've witnessed this as a nurse, and we've heard stories of people hanging on until the end, until a loved one comes. I believe that my role in walking my father through that process of dying was to sit there with him, hold his hand, pray with him, and I felt as a nurse the fear. He was afraid to let go. I think he was afraid of the decisions, the poor decisions he'd made in his life. It was a terrible divorce with my mother. He didn't see my sister. There was a lot of emotions involved at that time, and I got to sit there and walk him through that and let him know that he was forgiven for the mistakes that he had made, that it was okay to let go, that God was going to be waiting for him. And I want to tell you a really important little story that I know many healthcare workers have experienced this. My mother and father, when I was 15, they had a very, very tumultuous relationship and divorce. My mother supported me in my decision-making to be there for my father, even though she said she was not going to go. She was not going to be there with him, didn't want to see him. She still hated him. The night he passed away, my mother called me and she said, "Where are you at?" And I said, "We're up at Applewood." And I said, "Are you coming up here?" And she said, "Yeah, I just got a funny feeling that you need me and I need to be there for you, so I'm going to come up." So she comes into the room. As a nurse as well, she pulled the covers back. She said, "Oh, yes, he's modeling. It should be no time now." She touched his leg and she said, "Randy, I will see you on the other side. All is forgiven." And I said, "Thank you, Mom." And I walked her to the back door and I come back. I washed my hands. I went to my father's bedside and he was gone. It was as if he waited for that thing that he was holding on to. And this happens all the time in healthcare. And we need to treasure those moments and not focus on sending our families to courts to fight over guardianship. So really briefly, I will go through this. The background story is the most important. The importance of these bills is they create a legal framework for a surrogate healthcare decision maker or next of kin. They provide clarity on who is to make those decisions when a person becomes incapacitated that does not have a power of attorney in place. And that is the very important part that we must understand. This will not supersede a durable power of attorney. But what it will do is it will allow family members to make those decisions should something happen very quickly and there is no power of attorney in place. Families will be forced, if we do not do this, to continue going to court to obtain guardianship for their loved ones that will delay the time that is needed to spend with those loved ones as they pass. This issue is personal to me. As I stated, these bills offer the clarity, support, and peace of mind for families across our state. And time is of the essence. It really is, guys. Families should not be spending the time with their loved ones outside of these hospitals in courtrooms. They should be with their families. These bills create a prioritized list of individuals who can serve as next of kin or surrogate decision maker in a medical crisis. Next of kin traditionally means the closest living relative, and in most cases, this will mean a spouse, a parent, adult children, and siblings. These bills define responsibilities and limitations of surrogates and include safeguards to prevent abuse and to ensure the alignment with the patient's wishes. As a nurse, as a daughter, I know that these decisions are very difficult for families and they're incredibly challenging. I've seen this as a nurse, and now I've experienced this as a daughter who had not lost I had not lost a parent. I wasn't aware of how the system worked until it happened to me. Thank you again for taking up these bills. We have worked very closely with the Health and Hospital Association, also with Elder Justice. They're going to speak today in support of these bills. And this is very personal to me. This is unlike anything I've ever had to live, and until you live it, I don't think you know. I will say that I've had many, many nurses, especially hospice nurses, reach out to me personally thanking me because they are seeing this on a daily basis. And again, until it happens to your family, we're not aware of some of the legislation that we need to adjust and come up with real solutions for families. And this is a very nonpartisan, very important issue. So thank you for your time, and I yield the floor to the other to Nicole.
Thank you so much, Representative Thompson. Thank you to Chair, Vice Chair, members of the committee today for allowing me to testify. My name is Nicole Shannon. I'm an attorney with the Michigan Elder Justice Initiative. We are a private nonprofit. We protect the rights of and empower low-income older adults and adults with disabilities. I am so fortunate to have been working on this issue for many years, and I appreciate our sponsors for bringing this issue to you today. This legislation has been developed based on national best practices, but it is also very specific to Michigan in the process and the procedure that we went about in drafting this bill. And so, as Representative Thompson has explained, right now, if an adult is unable to make or communicate informed medical decisions, and they don't already have a patient advocate designation, which is the Michigan term for a medical power of attorney, really the only option is guardianship. And in contrast to over 30 other states, Michigan does not automatically allow next of kin to make these medical decisions. And this forces, as Representative Thompson just shared, this forces families into the guardianship system. It delays important medical decisions, and it just serves no one well. And it is easy to understand the implications of this bill with an example. Representative Thompson has shared her personal story. I'll give you another example. And perhaps imagine that your 65-year-old uncle, he's had a stroke. He was immediately stabilized and he's now recovering, but right now he can't make or communicate those informed medical decisions. Doctors expect him to recover. He's single, he never signed a designation of patient advocate, and right now he doesn't have anybody to consent to medical treatment on his behalf. And under the status quo, the next step would likely be guardianship. The hospital needs someone to consent to treatment and discharge planning. Without a legal decision maker, there's really no other option. And so once your uncle recovers, he would need to go through this time-consuming and stressful process of trying to ask the court at that point to terminate the guardianship. Under this bill, things would be different. Your uncle's closest family member would have priority to serve as his medical next of kin decision maker. And if there are multiple people at the top priority level, and I'm really excited about this kind of innovation for Michigan, because again, it is based on best practices nationally. If you've got multiple people at that top priority level, for example, 3 siblings, they pick one person to act as the spokesperson. And so that way the doctors aren't having to go back to basically take a straw poll or a vote of the entire family every time you've got to decide to give somebody a Tylenol. And so they'd select one person to act as a spokesperson. If there's disputes, if there's confusion, guardianship continues to be available, but as we've seen in the 30+ other states, this regime will typically avoid guardianship. The next of kin decision maker would have the same authority as an agent under the most basic patient advocate designation. So it does not include authority to stop life-sustaining treatment or consent to mental health treatment. Once your uncle makes his recovery and can again participate in his medical decisions, the authority of his next of kin would stop. This bill uses the same standard for determining whether a patient has capacity as under the Michigan Patient Advocate Designation statute. That's 2 doctors or a doctor and a psychologist determining that you no longer have capacity to make medical decisions. And so as my colleague Elizabeth Cutter, I think, will explain, this is good for hospitals because they don't have to pick, is this a patient advocate designation? Is this next of kin? It's the same system for everybody. It's just a different way to get there. Michiganders are still free and encouraged to execute patient advocate designations. These are very important documents that allow a person to specify who they want making these decisions and what their wishes are regarding care. But for the millions of people, and I would guess there are plenty of us in this room here today who have not signed these documents, this bill is going to provide an important default. And so thank you. I know my colleague Elizabeth Cutter has additional information, but I'm happy to answer any questions.
Thanks, Nicole, and thank you, Representative Thompson, for sharing your personal story. Thanks to everyone that's already worked on these bills. In the interest of time, to some extent, Nicole and Rep. Thompson really shared all of the details of why this is important. And for us as an association, this is really about effectuating patients' intent, making sure that we're supporting families, and making sure that we're able to do what makes best sense for that patient. And right now, the legislation would give us that chance. The law in Michigan doesn't currently allow us to do this. This is sort of what happens in the movies and what everybody already believes is the case, but is not the case here in Michigan. And we're really excited to align with the over 30 other states that do this. So thank you again to all of the folks who have already worked on this, who have weighed in on it. It's been an incredible process to really bring us to best of standards in the state.
Thank you, ladies. Is that all you wanted to testify to, or do you want to go into it right now? Because
No,
since you're sitting
I'm
here.
good.
Okay.
Most of it was already stated, so I feel like it would be silly to give you the same statement over and over again.
Okay.
Unless you want me to, I'm more than happy to reiterate everything that everyone's already said.
No, we're good.
That's what I figured.
Okay. Well, thank you, ladies. And I already read in your cards as you guys come up, so those are taken care of. So unless you have any other further comments, we'll go ahead and bring Genevieve up and then do questions. Is that okay, Jamie? Are you good with that? Okay. All right. Thank you.
Thank you, Madam Chair, members of the committee, for giving me a few minutes to testify on behalf of House Bill 4418 and 4419. And no, I won't take 25 minutes. My name is Genevieve Martin. I'm the Legislative Director and Senior Policy Advisor for Right to Life of Michigan. And many of you are familiar with Right to Life of Michigan, but perhaps many of you do not know that Right to Life has been engaged in the end-of-life and patient protection sphere for decades. I've been actually working on this legislation for 8 years now. Right to Life of Michigan was involved in the drafting of the Patient Advocate Law, the Physician Scope of Treatment Law, the Do Not Resuscitate Law, and multiple other laws pertaining to guardianship, hospice, and palliative care. Informed consent regarding medical treatment decisions remains the fundamental principle in upholding the dignity and rights of every patient. Historically, as you've heard, family members have been allowed access to medical records and to be able to direct the care of their loved ones without needing any paperwork or statutes to do so. But due to medical privacy laws and concerns about liability on behalf of the medical community, a legal avenue to provide liability protection has become increasingly necessary. Without a legally appointed patient advocate or a court-appointed guardian, doctors are left without a clear decision maker, and patients are left without a loved one legally authorized to direct medical care on their behalf. House Bill 4418 and 4419 seek to alleviate these concerns, and my research showed that 46 other states have adopted similar laws to this. So while I wish these bills weren't necessary, the fact remains they are. While the process for designating a substitute medical decision maker currently exists in law, as you heard, many people do not have the necessary paperwork filled out. Having contemporaneous consent based on current medical situation is patient protective, and having someone that you yourself appointed to make those decisions is always the best scenario. In Michigan, the durable power of attorney for health care or patient advocate law has been on the books and working well for decades, and it is the gold standard for a substitute medical decision maker. So just because we pass this doesn't mean you don't want to fill out a patient advocate form. You want to be able to designate your own decision maker in advance of needing one. But this is a great second option if we need it. It would be ideal if everyone had a patient advocate form filled out in advance of ever needing one. The reality is that several simply will not. And I want to tell you my mom's story real quick. My mom did go through the work of filling out a patient advocate form and a durable power of attorney for healthcare and finance and a will and all of that stuff. My mom and dad sat down and they filled it all out many, many, many years ago and never bothered to tell us where it was. We all knew I was the patient advocate. I had been told that. I knew that that's the case. Do you think I could find that paperwork when my mom had her stroke? We turned that house upside down, inside out, and backwards, and I could not find the paperwork. Now, fortunately, I found the financial power of attorney paperwork, so I was able to pay her bills and make financial decisions on her behalf. But as far as making medical decisions, right now, and it's not really legal, I mean, they do it. It's called consensus of the family. All of us agreed this is what mom has to have done, and so the doctors did take direction from us. But when it came to moving her to a nursing home, I had to go to court and get guardianship. I'm my mom's legal guardian. Now, these bills here are not going to alleviate the necessity to get guardianship or conservatorship in many cases because the patient may never regain capacity like my mom hasn't. I'm still her guardian 2.5 years later, and even if this were in place, I could have made those immediate decisions, which would have been very helpful, but I would still have to go to get guardianship. So these are not a panacea per se, but they are an excellent situation, an excellent law that will help in emergency situations. So I just want to kind of make that point clear. And as Rep. Thompson said, rather than subjecting families to the onerous, it is onerous. It's intimidating to go to court and become a guardian. You have to fill out paperwork, and it's costly. And they invade your privacy. And as Rep. Lightner mentioned, once you have a guardian, in order to get rid of a guardian, it's a big, long process. So if you gain capacity, trying to get rid of that guardianship is really, really difficult. So the surrogate medical decision maker law allows for it to just go away after the acute episode has passed. So that's just something to keep in mind. So I do applaud the sponsors and Rep. Breen from last year, and before you, there was Rep. Bolin and Rep. Cole and Rep. Noble. This has been kind of in the process for a while. But I do want to point out just a couple little things that I hope will be included in a substitute. On page 8, regarding the section about a dispute and allowing someone to go to court to petition the court in the event of a dispute. The bill says to appoint a surrogate. There's no legal rubric for courts to appoint surrogates, so I think that should be changed to guardian, temporary guardian, or emergency guardian, just simply because the courts don't have a system in place for appointing a surrogate. I think that was just an oversight. But the second issue that I wanted to point out was in the enacting section, all those sneaky little enacting sections, you don't read them, right? It says it repeals MCL 466H. Well, what is MCL 466H? I had to go look it up. It's the law that requires medical personnel to get consent before any medical treatment or surgery is provided. Now, I don't know about you, but I think retaining legal requirements for doctors to obtain consent before treatment is kind of important, and I don't think that part should be repealed. Now, I understand it would need to be modified to include a surrogate medical decision maker, and I have an amended bill for that process, and I'm hoping we'll be able to take that up. So that's all I have. I hope we can get to a really great product here, and Michigan will become another next of kin state. Appreciate it. Thank you.
Thank you. Well, ladies, it looks like everybody did a really good job. There are no questions at this time. Obviously, there's some things that need to be worked through, but, as one that had to deal with this personally, too, myself, with an aunt that wasn't really my aunt, I can't express how necessary it is for people to actually fill out their paperwork, and especially the patient advocate part and then their directives. Because, you know, in my case, my aunt actually changed her directives and didn't mark them the second time when she changed her paperwork the few months before, and so I had to do all of that. So I would just encourage people, if you do your paperwork, do your paperwork. Right, and let people know where it's at. So, but with that, we have a couple more cards to read in. Emily Henderson from, Michelle Roberts with Disability Rights of Michigan supports House Bill 4418 and 4419 and does not wish to speak. And then we have Richie Farron of HCAM supporting the bills and does not wish to speak. All right. Well, with no further business before the committee, we will be adjourning. I already did it.